people, here's a thing that people ask all the time. What should I name my trust and who should be the trustee? Can we just go over a couple of those?
Sure, be glad to. In fact, I spend a fair amount of time. I always say in my seminar that my favorite part of teaching that class is the naming your land trust part, because it allows for the most creativity and the most fun. If you can make creating land trusts fun,
Yeah.
it does help make it fun. And here's what's interesting about the naming process. If you go to, let's say, an attorney or some professional for advice about a trust, and you said to them that you learned in a land trust seminar that this guy said it's important to come up with a good name for your trust, they would probably laugh and say, well, that, naming the trust means nothing. But I think that's the difference between, especially with attorneys. Attorneys are very smart. They have to be smart to get through law school, but they are more memorizers than they are thinkers. And what I mean by that is most attorneys, if you go to them to set up a trust, they're going to say, well, let's name this the Don Rickabaugh Trust Number 1-10. And they don't think streetwise like us real estate investors have to. And that's what I teach in my class is be creative and come up with a name to your trust, each one of your trusts, that is has maybe a little intimidation sound to it. Maybe it implies that there may be a legal department behind that trust, and maybe you don't really want to sue this trust. You'll go sue some other mom and pop trust before you sue the East Coast, West Coast Global Investment Fund.
Yeah.
So there is a lot to a name. Just that name alone can stop the potential lawsuit in its tracks.
Right. Well, plus you don't really want. I mean, one of the things about a land trust is privacy. So why would you have your personal name as part of the land trust, or even the address of the property, even, right?
Exactly. I've even seen attorneys put the Social Security number of the beneficiary in the name of the trust.
Wow.
And then go another step further, record the trust agreement. And that's just insane, but it gives you an idea of the type of bad advice you can get out.
Yeah, absolutely. And how about who should be the trustee? Because sometimes people just have one or two and they don't want to pay $700 a year, to have someone do it. They're asking, who can I get? Can I get my brother? Should I get my attorney? Should I get my CPA? Should I hire somebody? What do you think about that?
Well, actually, all those people would work. Pretty much anybody can be a trustee, an individual or a trust of another trust, mm-hmm. or a corporation, although you have to be careful because corporations and LLCs in some states like Florida are required to have a certain amount of insurance, mm-hmm. and financial backing before they can offer themselves up as a trustee service. So I always advise people that if they're not going to use an institution like a bank trust department, to use someone that they trust, that's an individual, and preferably somebody that's out of state and that has a different last name.
Now, why out of state? I think this is an important distinction.
Well, as people learn more about what I teach in my trust courses, they'll find that I like to use out-of-state land trusts to hold title to property in my state. The main point here is that there's no federal land trust law. It's all state by state. So some states have better laws than others. In fact, there are only 6 or 7 states that actually have a land trust statute on the books. California is not one of them, but California does recognize the validity of a land trust. Mm-hmm. So what you're doing when you go out of state is you're kind of...
you're making it harder for someone to go after you because they're not sure what the laws are going to be. You got, okay, the collateral's here, but we don't know what the land trust law is going to be in Virginia or Florida or Illinois, for instance. And so it just is one more barrier besides naming it, of someone being intimidated by having to know the law in that state.
Yeah, that's exactly correct. So now you've got a an out-of-state trust, an out-of-state trustee. You got a name on your trust that's intimidating. You see how we're starting to build our fortress here.
Right, and we're not even talking asset protection here. This is only just privacy, initial barriers. Asset protection is a whole nother conversation that's not for right now. But
Well, no, and let me just say this: as you raised the concept of asset protection. The least expensive form of asset protection is privacy.
Right.
The least expensive form of privacy for real estate investors is a land trust.
Wow, that makes it pretty clear. You know, in terms of my world, in the owner financing world, trusts have become increasingly important. You know, people hear about doing subject to or wrapping, you know, an AITD, all-inclusive trust deed, you know, where the seller is leaving the existing bank financing in place. And then everybody's worried about how do we put together this deal that protects everyone as best as possible and also discourages the banks accelerating the loans, and how does it protect us if the worst case scenario and there's a default. There's a whole host of things that in the owner financing world, the trusts are a really valuable tool.
Oh, I definitely agree. I wouldn't do a transaction without using a trust, whether it's seller financing or not.
All right, so this is a good point, because right now we have a deal closing where it's being put in a land trust and there's a seller carryback, and immediately thereafter I'm buying that seller carryback. Okay, and I know the parties and I trust all of them, but you're saying that on that note and deed of, on both the note and deed of trust, more than the trustee who owns the property has to sign on both of those?
I would have a human being. A trustee is technically not a human being in this example. I would have a human being either sign the note or a guarantee of the note. Because if things go bad, you need somebody to go to, and you can't go to the trustee. He's not going to stand behind that.
Right, but it's a non-recourse loan, so I still have the collateral, right? Okay. If I don't get paid, I'm going to be able to foreclose.
Okay. If the deal you negotiated is non-recourse, then obviously you can't ask for somebody to have recourse.
Right.
I'm just saying, in a situation where there is recourse on the deal, make sure you get that beneficiary.
Okay, so but in the cases where the collateral is sufficient and the only thing you're going to look to for satisfaction, it's really not important, but...
Yeah, it's not important.
Oh, okay. Well, that's an important distinction. Well, thanks for mentioning that. I didn't think of that. Well, I think that's probably enough for today. I'll meet you same time next week, Randy, and you have a great Labor Day. To learn more about land trust, please join us for our one-day training on October 28th. On the next day, the 29th, is training on notes, discounted notes. Save the 28th and the 29th in Culver City. See you there.